My name is Natalie Chin, and today our assignment topic will be about rape in the law of England and Wales and also in Malaysia.
Hi, my name is Natalie Leaw.
Hi, my name is Pacey Ting.
And to our viewers, here is a short clip for you guys to enjoy.
Hi, what you doing here?
Hi, I'm just walking around.
You're actually very pretty. Can you be my girlfriend?
No.
Want to go to my place?
No, I don't think so. We're not that close.
No, just come. It's fine. It's fine.
No, I don't want to.
No, just come.
Wait, what do you think you're doing? Please leave her alone.
Where are you? Why are you here? We're having
She
fun.
doesn't look comfortable. Please don't touch her.
It's none of your business. Can you leave?
If you continue to harass her, I will call the police.
Okay, it's fine. I'll leave.
Thank you so much. Thank you for helping me.
Are you okay?
I guess I'm fine now.
Do you want to make a police report?
No, I'm scared. I don't want to. I'm so sorry.
Okay, make sure you take it and
Okay, thank you so much. Thank you so much.
So, do you think that the previous scenario amounts to rape? Well, it does not. It could amount to sexual assault, but not rape. The area of law governing rape in Malaysia is fairly different than that in England and Wales. Under the Malaysian jurisdiction, the law governing rape is the Penal Code, along with other criminal offences and procedures. Unlike so, the law governing rape in England and Wales is the Sexual Offences Act 2003. It is a separate and distinct legislation covering various areas of sexual offences. To determine whether there is a need for an amendment to the current rape laws in both jurisdictions, it will be essential to identify and analyse the differences and the current issues circulating rape.
So I'll be talking about the definition of rape in UK and in Malaysia. Definition of rape in UK is defined in Section 1 sub 1 of the Sexual Offences Act 2003. A person's A commits an offence if he intentionally penetrates the vagina, anus or mouth of another person, which we call B here, with his penis, and B does not consent to the penetration, and A does not reasonably believe that B consents. So the actus reus of rape is committed where a man has sexual intercourse with a man or woman without the person's consent. Thus, the actus reus of rape involves not only sexual intercourse but also the absence of consent. There are two elements here, which is the mens rea, where it must show that there's a lack of the victim's consent, and the actus reus where penetration of the vagina, anus or mouth or another person with the penis happened. Whereas in Malaysia, the law defines rape under sections 375 of the Penal Code as a man having sexual intercourse with a woman against her will without her consent. The difference of the definition in Malaysia and UK is that in order to provide sexual intercourse has taken place, the prosecution must prove that the accused penis penetrated the victim's genitalia. Sexual intercourse is complete upon penetration of the labia, either majora or labia minora, no matter how little, even though the hymen was never touched nor is there any penetration of the vagina. The word sexual intercourse in 375 in Malaysia is vague. The question arises where non-penal penetration happens. In the case of Bohari bin Amit and public prosecutor, the appellant was convicted for a charge of outraging the modesty of a 7-year-old girl by inserting his finger into the vagina of the little girl. This case raised the registrar's concern as to why Section 375 of Penal Code was not being applied in involving penetration by foreign object. It was then affirmed in the case of Bunya and Anak Jalong and public prosecutor. This is the decision of the Court of Appeal to acquit a 60-year-old man named Bunya Anak Jalong on the offence of rape has sparked outrage among public. The old man fingered the 15-year-old girl, but nonetheless acquitted because the prosecutor had failed to prove beyond reasonable doubt. It was held that the defendant could only be convicted when there was penal penetration, but not penetration by other means. Therefore, it could be concluded that non-penal penetration caused by foreign object is not regarded as rape in Section 375, but constitutes to other criminal offences. With reference to the discussion above, I hereby propose that there should be amendment to the definition of sexual intercourse, and the meaning of sexual intercourse should be the penetration of any extent of a man's penis into the vagina, anus, or mouth of another person, whether or not there's emission of semen, or the penetration of any extent of an object or any part of a person's body into the vagina or anus of another person, except in the course of procedure carried out for a valid medical treatment or is authorized by the law, or vagina shall include the external genitalia and a surgical constructed vagina.
What about men who get raped? It was reported that 1 in 71 male in the US have been victims of such act. In Malaysia, man is not protected from rape as Section 375 is a gender-specific law which states that man who is said to commit rape who has sexual intercourse with a woman. Thus, only male can be the perpetrator and only the woman can be the victim. Meanwhile, in UK, Section 1 SOA provides a wider definition where it made the victim of rape gender neutral, which was acknowledged as a crime in 1994. However, rape itself can only be committed by a man in both UK and Malaysia. As society matures, we must develop empathy for all, and this includes male and transgender rape victims. It acts as a means of acknowledging male victimizations so they could get aid and justice. Furthermore, it discriminates our Malaysian Federal Constitutions of Article 8, Clause 2, which provides that there is no discriminations to gender. Thus, Malaysia should move in the directions that has taken by UK, as SOA 2003 protects both men and women from serious sexual offendings. Thus, the gender-specific law of Section 375 should be changed to change the word woman to any person, so it focuses on the victim itself and not the gender. Perhaps if UK need amendment, it would be recognizing fully gender neutral, where women can commit the act of rape, as well as in Malaysia, but is yet still be seen.
As for the element of mens rea, Section 375 of the Penal Code does not expressly mention the requirement of it. It is dependent on the prosecutor to prove that the accused person had sexual intercourse with the complainant without her consent. In situations as such, where the defendant proceeds to have sexual intercourse with her, then the element of mens rea shall be said to be satisfied. However, Section 79 provides for the defense of mistake of fact, where any persons by such mistake acted in good faith is said to not commit an offense. This defense also applies to cases of rape. If the accused person believes that the consent was given by the complainant, then he can raise the defense of mistake of fact under Section 79. However, the burden of proof is on him to show that he acted in good faith. In English law, Section 1 of the Sexual Offences Act specifies that the element of mens rea is based on an objective test. As Section 1 sub 2 provides, whether or not the belief is reasonable is subject to consideration to all surrounding circumstances at the time of the relevant act. The question to be asked is whether the accused, having regard all circumstances, reasonably believed that the complainant consented to having sexual intercourse, with emphasis that the complainant had the freedom and capacity to make the choice. The jury will then have to determine what constitutes a reasonable belief. Accordingly, they will also have to determine what constitutes an agreement, freedom, capacity, and choice. Under the Penal Code, there is no such element of a reasonable belief. It is entirely up to the prosecution to prove that the element of mens rea is satisfied with regard to the circumstances described therein. As for the defense under Section 79, Section 52 provides that where the defendant acted with due care and attention, the element of good faith will be satisfied. The test of due diligence is one which produces an objective test in relation to the defense of an absence of mens rea. This shows that the definition of good faith is restrictive in nature as it is based on an objective test. It would be advisable for the penal code to adapt to the approach taken under English law by adding the reasonable belief element to determine whether or not the accused had the mens rea when committing the act. The legislation may also repeal the term of good faith and place more emphasis on the word honesty. The test would then be whether the accused honestly and reasonably believed that the complainant consented, having regard to all circumstances known to the complainant. By doing so, there would be a clearer understanding and guideline as to whether the accused honestly and reasonably believed that the complainant consented and whether the defense of mistake of fact under Section 79 would be applicable. Under the Malaysian jurisdiction, Section 375 of the Penal Code provides that rape is said to be committed where the complainant did not give her consent, where her consent was not given willingly, where she consented because she believed that the man was someone whom she would consent to, or where she consented because she was unable to understand the surrounding circumstances. On the other hand, under the English jurisdiction, Section 74 of the Sexual Offences Act provides for the definition of consent, where it states that a person is said to consent if he agrees by choice and has the freedom and capacity to make that choice. Also, Section 75 and Section 76 provides for evidential and conclusive presumptions about consent. These two sections were introduced so that the arguments in relation to rape will be controlled rather effectively. Section 75 of the Sexual Offences Act provides for evidential presumptions about consent, where in the situation where the evidence shows that the current situation falls into the said circumstances, then it shall be said that the complainant did not consent. These circumstances include using violence, inducing fear of violence, where the complainant was unlawfully detained, where the complainant was asleep or otherwise unconscious, or where the complainant could not communicate her consent due to her physical disability, or where the complainant's mental capacity was impaired due to taking some sort of substance like drugs. Under Section 76, in the circumstances where the complainant was deceived by the defendant as to the nature and the purpose of the relevant act, or where the defendant impersonates someone known personally to the complainant, it shall be concluded that the defendant did not believe that the complainant consented to the relevant act, and also that the complainant did not provide her consent. Unlike Section 74 of the Sexual Offences Act, the element of consent is provided in Section 375 of the Penal Code itself. There is no distinct section and also no mention of evidential or conclusive presumptions like Section 75 and 76 of the Sexual Offences Act. It is arguable that, as compared to the Penal Code, the Sexual Offences Act provides a clearer picture as to when the consent of the complainant is not given. The definition of consent under the Penal Code of Section 375 is still vague, which may be subject to manipulation by the accused and also prejudice towards the victim. It would be advisable for there to be added provisions to the definition of consent, like Section 75 and Section 76 of the Sexual Offences Act, which is more specific as to when the victim's consent is not given.
If you are married and if your husband forces himself onto you, is it rape? It was said that a marriage can be called a license to rape. In Malaysia, Section 375 exception states that sexual intercourse by a man with his own wife is valid, thus marital rape is not a crime. Although 375A is added, JG has said that this offence against men causing fear of death or hurt to their wife for sex is a mere compromise and inadequate to prevent marital rape. It was said that the reason to why it has not been a crime yet is because it would conflict Sharia law, and government has said that marital rape is hard to prove in the court. Furthermore, Malaysia, as part of its obligations under UN conventions, and has also ratified CEDAW in 1995, when members are criminalized from marital rape. It shows that Malaysia has not complied to the basic women's rights. It has also violated Article 5 and Article 8 of the Federal Constitutions that provide for right to life and prohibits gender discriminations. While in UK, the Court of Appeal of R&R held that husband can be convicted of rape if wife had withdrawn consent to sexual intercourse. It's evidence that the law must change due to the changing era, and it must be noted that Section 375 is introduced based on common law. Thus, reform has to be made, just like how UK has criminalized marital rape. Besides, it has caused problems where by marrying off victims, it has allowed perpetrators to escape from punishment, as in Malaysia, the marrying age for Muslim girls is 16 years old, but is allowed to marry earlier with Sharia court permission. For an example, Ahmad Shuki Yusuf, whom has raped 14 years old girl but was dismissed after he married the teenager. Thus, this shows that by allowing girls to marry before age of consent, and the exception in 375 has left girls vulnerable to sexual abuse. Thus, the penal code needs to be amended by deleting the exceptions and explanations to Section 375 and Section 375A. It was reported that for every 35 minutes, a woman is raped in Malaysia. This rising trend shows that punishment should be added to reflect the gravity of the crime. In Malaysia, Section 376 Clause 1 provides that whoever who commit rape will be punishable with imprisonment of maximum of 20 years and possible whipping, or a maximum of 30 years and minimum of 10 years if the rape offence fall under circumstances stated in Section 376 Clause 2. What peculiar is even for offences under Section 377 and Section 377C, the same punishment as rape, which shows that the disproportionality. In contrast with UK, such offence of rape and as well as assault by penetration is punishable by life sentences under Section 1 Clause 4 and Section 2 Clause 4 of SOA. Therefore, there's a big difference of deterrence between Malaysia and UK. Besides, not only does it provide a minimum protection for wife, Section 375A provides that husband can be charged for a maximum of 5 years, where it is a much lower punishment of rape and disproportionate to the gravity of the offence. However, in UK, marital rape is accepted as to be the same as other rape, thus it is subjected to life imprisonment. Cases such as Ismail bin Rashid and public prosecutor has told us that life punishment is given instead, then it would not have a deterrence effect. Thus, the punishment under Section 376 need to be amended to cater heavier punishments, such as including mandatory death penalty if death occurs from rape, impose punishment equally to the husband, and increase jail sentences and possibly public whipping, particularly when minors are involved. Other factors like whipping should be made mandatory as well.
The question then arises on whether there's a need to have anti-rape law in Malaysia. According to Pakatan Harapan's manifesto and statements made by our previous Deputy Prime Minister, who was also the previous Minister of Women, Family and Community Development, Dato' Sri Dr. Wan Azizah Wan Ismail, she had proposed to have sexual harassment bill which aims to protect women's right and dignity. And she pointed out that the definition of sexual harassment is unclear in the penal code, and it places the burden of proof on victims to prove beyond reasonable doubt, which oftentimes it's difficult to do so. And however, she went on saying that This sexual harassment bill will not only be applicable to women, it will also be applicable to men, as they could also be a victim. The sexual harassment bill works similarly to the anti-rape law that we are about to discuss here. The Joint Action Group, which we call JAG, Joint Action Group for Gender Equality, JAG, has called for an amendment to the existing rape laws stipulated under the Penal Code. But all these have come not until today. There is definitely a need for new legislation for rape, following are the proposed areas that to be included in the new legislation. The most crucial amendment that should be made is expand Section 375 of the Penal Code and also Section 376 to include non-penal penetration. So, in my proposal, it should be changed to penetration of the vagina or anus with any body part or object, or oral penetration by a sex organ of another person is sufficient to constitute the sexual intercourse necessary to the offence of rape. My second point is, the law should not only mention women as the victim. The man could be the victim as well. It must be inclusive in those who is covered under the scope of the law. Any individual who experiences rape, regardless of the context, whether professional, educational, religious, public or private, must have the ability to seek protection and recourse. The law must equally protect every person regardless of location or legal status. My following point is this. The definition of consent is still vague in the Penal Code and has no clear definition on what constitutes the consent. There should be a clear distinction between consensual cases involving sexual exploration between teenagers who are very close in age and cases where there's no consent at all. The fourth point is, the accused may use Section 79 to get their way out and argue that there was no mens rea in raping, since mens rea is not specifically mentioned in Section 375. However, instead of focusing on good faith as mentioned in Section 79, the law should put more emphasis on honesty, and instead of focusing on good faith, which uses the objective test, a substantive test should be used. Following, the law should govern marital rape and remove the exception in Section 375, which mentions that a sexual intercourse between a married couple should not be considered as rape. Despite the amended section, the Penal Code still does not criminalize marital rape. For sexual intercourse with the wife, even when she has rejected the sexual advances, is not regarded as rape unless the husband causes injury when intending to have sexual intercourse. The law should also implement a heavier punishment to deter the potential perpetrator. The researcher opines that there should be a minimum term of imprisonment provided in Section 376 sub 1. Without a benchmark sentence, a court can impose any minimum sentence. And in fact, there are still cases where the judge only imposed 2 years imprisonment. So why is it so important to have anti-rape law in Malaysia? We need provisions to adequately protect and offer redress to all survivors of rape. In absence of a specific legislation, the issue of relating to rape in the country has been ignored. And we are in need of effective complaint and solution mechanisms, remedies and penalties. And according to the Star newspaper, only 10% of the cases were reported. And lastly, we need professional forensic medicine to provide a more accurate medical report. As such, we need a law to deal exclusively and conclusively with this matter.